Excited Utterance, the Evidence and Proof Podcast, Episode 168, Avani Sood, Verdict Format on Trial. Welcome to Excited Utterance. I'm your host, Ed Cheng from Vanderbilt Law School. Excited Utterance is your podcast for cutting-edge scholarship and developments in the world of evidence. We bring virtual workshops to you throughout the academic year. This week, our guest is Avani Sood. Avani is professor of law at NYU Law School, where she teaches criminal law and psychology. Our podcast today features Avani's new article, Verdict Format on Trial, Experimentally Challenging Half a Century of Criminal Law Orthodoxy. It's forthcoming in the Vanderbilt Law Review. In it, Avani challenges our legal system's strong preference for general verdicts in criminal cases. As most of us know, criminal cases are almost always determined with a general verdict, a simple guilty or not guilty verdict that you're probably familiar with from the news or movies. Unlike in the civil context, criminal juries are basically never asked specific questions that break down the facts or the elements of the crime. The question, of course, is why? On the one hand, general verdicts might be good for defendants, since they allow juries to more easily ignore the law and engage in jury nullification. On the other hand, special verdicts might be better for defendants because the specific questions emphasize to the jury the burden of proof, which is beyond a reasonable doubt. Special verdicts also demand strictly reasoned convictions and prevents a jury from engaging in gestalt findings of guilt. Avani's article illuminates these questions and more, specifically through several detailed psychological experiments. My conversation with her discusses the experimental results, as well as unpacks the choice between general and special verdicts in criminal cases. Avani, delighted to have you on Excited Utterance. Welcome.
Thank you. I'm thrilled to be here.
So your new article is part of what is really a trilogy of scholarship that focuses on special verdicts in criminal cases. Can you tell us a little bit about what got you interested in this issue?
Sure. So, Ed, my scholarship generally draws upon tools of psychology, including the experimental method, to test the criminal legal system's assumptions about how its decision makers and its rules and its procedures operate. And I'm especially interested in identifying and addressing disconnects between legal assumptions and the psychological realities of the decision makers who are applying the law. And my concern is that those disconnects risk undermining accuracy and fairness and transparency and the very high stakes of the criminal legal system. So, in prior work, I've explored these kinds of disconnects in regard to broad principles and theories of criminal law, like the harm principle, and also in specific doctrinal contexts, like the exclusionary rule or laws of criminal attempt. And with this project, I turned in a different direction to looking at an entrenched procedural practice in criminal law, which is the format in which criminal jurors deliver their verdicts, which remarkably has never been empirically tested. The assumption that criminal law has made, really for centuries, is that criminal jurors should only deliver general verdicts because the special verdict format is going to harm criminal defendants. So, the general verdict, which is the default verdict format in criminal cases, is where the jury basically just returns their legal conclusions of guilty or not guilty. They don't speak to how they reach those conclusions. There's no guidance given to them on the verdict form for what questions they have to go through to get to those conclusions. It's just very laissez faire, entirely open ended. And this verdict format is therefore believed to give jurors maximized autonomy and discretion and sort of going about their deliberation process, how they choose to reach the legal outcome. The other variation of verdict is a special verdict. And these are used in civil cases, but not in criminal cases. Now, civil cases have two versions of the special verdict. One is what's called the true special verdict, where the judge gives the jury interrogatory questions on every element of the law that they're supposed to address. The jurors answer these questions, and then the judge applies their answers to the law to reach a legal conclusion. That format, I'm going to just take off the table. It's not viable in criminal cases because the criminal jury to reach the ultimate conclusion of guilty or not guilty due to the defendant's constitutional right to a jury, etc. So we're not talking about that, very limited type of special verdict. What we're talking about here is another variation of the special verdict in which jurors are given these questions that go through every element of the law that has to be proven beyond a reasonable doubt in order to convict. And they have to answer affirmatively whether every element has been proven. And then they themselves use that answer to deliver a verdict of guilty or not guilty. And they submit the responses to the questions to the court along with their legal conclusion. So, this format of the special verdict both guides jurors in regard to every element of the crime that they have to address, and it also provides courts and the public insight into how they went about that process.
The standard story, though, is that special verdicts have long been highly disfavored in the criminal system. So, why is that?
The judicial presumption has been that special verdicts will harm criminal defendants by constraining the jurors' autonomy. And what's interesting about this is the leading legal authority in this regard is a case called US v. Spock that took place in the 1960s, 1970s. And it was a case that was very unique. And one of the parts of my article talks about all the reasons why it was a very unusual set of circumstances on which to base such a huge legal precedent. So the Spock case involved Dr. Spock, who was a very renowned pediatrician and author of this best-selling book on how to raise babies and children. And he opposed the Vietnam War. And Bach and some co-defendants were charged with conspiring to help young men evade the mandatory draft for the war. So these were unusually sympathetic defendants. It was a very unpopular criminal charges that had been brought against them. And long story short, this was a case that would have been ripe for jury nullification, where the jury basically says, yeah, we see what the law is, we see what the evidence is, but we just don't think this should be a crime or these particular defendants should be punished, so we acquit them. Now, in that case, the trial judge decided to give the jury these questions that basically asked them about the specific charges in the case. And the jury ended up convicting most of the defendants, all but one. And the appellate court blamed that on those questions and basically said it's because of that special verdict that the jury's arms were tied, that they were forced into a conviction that they otherwise would not have delivered. And it reversed those convictions. The Spa court's reasoning and basically conclusion became a key precedent for courts across the country. So you see this across every jurisdiction, state and federal. You see it at the trial level, at the appellate level, that courts again and again are saying that we disfavor special verdicts because they constrain jurors and they prevent jury nullification and therefore harm criminal defendants.
So immediately, I think you see something of a tension, which is that, yeah, if you have a special verdict, it can be pro prosecution because it prevents jury nullification. But at the same time, I think we all know this from experience as legal thinkers. Step by step decision making can be extremely pro defense because it ensures that the jury find every element beyond a reasonable doubt.
Exactly. And what's interesting is civil litigators who routinely use both special and general verdicts in their cases have long said the inherited trial wisdom, to quote Elizabeth Thornburg, who's written about this in civil law, is that special verdicts favor the defense. Because the way that civil litigators put it, the defense only needs one no to any of those questions in order to prevail. Whereas the party that bears the burden of proof, which is the plaintiff in a civil case and the prosecution in a criminal case, has to get yeses to every single question in order to prevail. And remember, in criminal cases, the burden of proof is even higher. It's a beyond a reasonable doubt. and there's a requirement of unanimity. And these are all protections for the criminal defendant because of the higher stakes of criminal cases as opposed to civil. So the rationale here is, well, wouldn't special verdicts therefore actually help enforce those protections, those constitutional protections for jurors, rather than harming them?
So let's turn to the meat of the article. The article has two big parts, this survey part and an experimental part. And so let's start with the survey first. What were you trying to get at with the survey? And just in a brief synopsis, what did you find?
Sure. So the survey results, which are summarized in this article, were actually published at length and in great detail in a prior article that came out in the NYU Law Review. And what I was trying to do there is it was sort of my first empirical step to say, okay, there's this conventional wisdom of criminal law that says special verdicts harm criminal defendants. And that is the basis on which verdict format is determined in most criminal cases. Do legal stakeholders agree with this? Is this consistent with how they sort of think about verdict format? So I decided, well, let's start by just asking the stakeholders in the criminal legal system. So for the survey, I reached out to over 1,600 individuals from 10 different stakeholder groups. I was focusing most heavily on repeat legal actors in criminal cases. So I had, almost 300 judges, about 250 prosecutors, and then about 200, 250 public defenders and private criminal defense attorneys, respectively. And these were mostly litigators and judges practicing in state courts where the bulk of criminal jury trials occur, although I did also have appellate judges and litigators in the sample. In addition, I looked at the views of professors, criminal law professors, as well as civil law professors and civil litigators, because as I said earlier, special verdicts are used in civil cases. So I was interested in their views as well. And then I had this group that I tapped into who I call criminal science experts. And this included criminologists, forensic scientists, law and psychology scholars, jury consultants, litigation data analysts, clinical psychologists who testify in the criminal legal system, just folks who have advanced degrees in fields relating to science and or criminal law, and therefore can kind of bring that perspective. And then finally, I also spoke with a couple of groups whose views are not considered, I think, enough in scholarship. One was jury eligible lay citizens, the people who would themselves be called for jury duty and would be rendering these verdicts. And then I also talked to law students. And one of the reasons I included them in the survey, and when I say talk to, I mean surveyed the law students, I included them in the survey because most of the scholarship that has been written questioning verdict format in criminal cases has been by law students. It's been in student notes and student comments as opposed to from their professors. And I think part of this is because law students probably most relate to the position jurors are in. They're learning the law, they're learning how to apply it to the facts of the case. And they get how difficult it is that I think sometimes those of us who are later in our legal careers are more distanced from. And they are the only ones who've really been questioning, wait, why are we not giving jurors more guidance on this? So I surveyed all these different groups of stakeholders. And basically, I was asking them first about their views on verdict format. And then, secondly, their predictions. Like, how do they think verdict formats will affect legal outcomes, processes of jury decision making, jury deviations from the law in the form of nullification? It was a long survey, many questions, and I was very pleased with the response rate that I got really from stakeholders across the country. And there were a couple of particularly striking findings. It's hard for me to limit myself to just a few because there was a lot that came out through the survey, but let me just highlight a few things. So, number one, contrary to the legal status quo in favor of general verdicts, the respondents in the majority of the stakeholder groups, so 7 of the 10 groups, including public and private criminal defense attorneys, criminal science experts, and jury eligible lay citizens, on average, supported the use of special verdicts in criminal cases. I also had former criminal defendants and jurors in the sample, and they also, on average, supported the use of special verdicts in criminal cases. Judges and criminal law professors, on average, expressed neutral views towards special verdicts, and the only stakeholder group to oppose the use of special verdicts was prosecutors. So, this just in itself is telling you that the rationale that special verdicts harm criminal defendants seems a little suspect given that it's the prosecutors who are most opposing special verdicts and the criminal defense attorneys who are supporting their use. When I asked about the status quo in favor of general verdicts, I saw an inverse pattern of results. whereby it was the judges and prosecutors, who are the most powerful players in the criminal legal system, who supported the status quo, which helps to also explain why it endures, whereas the particularly public criminal defense attorneys and law students opposed the status quo in favor of general verdicts. So that was one main finding.
Super interesting results, right? There's seems to be an upswelling of interest in having special verdicts, or at least some support. And so the question I think then became for you, well, do we have a sense of what special verdicts would actually do? So not just impressionistically from your survey respondents, but from psychological experiment perspective. And so I should say at the outset, and I said this before the interview, that you're going to really hate me because I'm going to ask you to summarize in broad brush what is really a very rich data set. And I should say for members of the audience who are interested in this, you should look at the paper itself. But I just wanted, in the time remaining, to talk about these experiments. One was a standard homicide case, and the other was probably best characterized as a mercy killing. Let's start with the standard case first. What did you find in those cases? What was the effect of imposing a special verdict type format?
In the standard homicide case, so this was a case of an intentional killing, and it's one that actually we use in 1L criminal law to talk to students about the different types of intentional killing, first and second degree murder, which can be mitigated down to manslaughter if it was provoked. So there were four different options that the mock jurors could deliver: first degree, second degree murder, manslaughter, or acquittal. And what I found in this case is that the defendant actually fared better under the special verdict than the general verdict. And in particular, 97% of the acquittals that were delivered through special verdicts, whereas the majority of manslaughter convictions were delivered under the general verdict. So this finding in itself was interesting because it is contrary to what the status quo of criminal law predicts. I should note we didn't talk about the surveyed stakeholders' predictions, but the stakeholders had predicted that special verdicts would actually lead to more acquittals rather than more convictions, partly reasoning along the lines that you and I had spoken about earlier about, enforcing every element of the law, etc. So this finding was more consistent with the prediction of stakeholders than it was with the conventional wisdom of criminal case law.
And there were some complicated race effects in the study, right? Specifically regarding race of the defendant and the effect that the special verdict had on the outcome, depending on the race of the defendant.
Yes, so I manipulated, in addition to randomly assigning mock jurors to deliver either a special verdict or a general verdict, I manipulated the identity of the defendant through his name. So his name was Jake Becker, Deshaun Washington, or Muhammad Khan. And these names were chosen based on empirical data suggesting that those first and last names are associated broadly with white individuals, Black individuals, and Muslim individuals of color. And the manipulation checks confirmed that the participants did presume these identities. They also presumed that the white and the Black defendants were Christian. So they imposed presumptions about religion on those defendants as well. Just backing up for a second, I'd mentioned that the majority of acquittals were delivered under the special verdict. A key factor here, which is relevant to the race of the defendant, is that these were not nullifying acquittals, these were grudging acquittals. So after the participants had delivered their verdicts, I asked them, all right, well, if you were not constrained by the legal instructions and no one was going to question you on your outcome, what outcome would you have preferred to deliver in this case? And what I found is that the majority of participants who had acquitted the defendant actually wanted to convict him instead. And this grudging acquittal effect was strongest in regard to the Muslim person of color defendant, where every participant who acquitted him, every single one, said they would have preferred to convict him if they were not constrained by the law, and not just of manslaughter, but also of murder, including all the way up to first degree murder. Meanwhile, the participants were most likely to acquit the Black Christian defendant and express sympathy toward him, and those acquittals were less grudging. I'm going to race into another interesting finding here because I know we're limited on time, is they also rated the Black defendant as more mentally unstable than the other two. So, the paper gets into stereotypes about race and mental instability. It gets into why is it that we saw certain biases emerging against the Muslim person of color that we did not see against the Black defendant. So it's, as you said, a lot of things going on here that were being surfaced in this experiment.
Now, let's talk a little bit about the mercy killing case, which is, of course, a very different context. That's one of those contexts where you were talking about where nullification might actually be something that is on the jurors' minds. What was the basic setup there, and what did you find there?
Yeah, so it seemed to me, given that the status quo is the leading legal authority, very sympathetic case, I felt it would only be fair to also test the effects of verdict format in a more sympathetic context. So, as you mentioned, this was a mercy killing. The son basically decides to give an overdose of morphine to his terminally ill and suffering father. There's indications that that's what the father wanted, etc. And here I found a very different pattern of results. So the defendant did indeed, as per the conventional wisdom of Spock and criminal case law broadly, did fare better under the general verdict, where they were not constrained by those interrogatory questions. They could just deliver the verdict that felt right to them. And in this case, what we saw is not so much acquittals, but mitigated convictions of manslaughter. So rather than finding the defendant guilty of intentional murder, they were reducing the charge and convicting of manslaughter. Here again, there was a twist to the tale where this lenity that we saw under the general verdict that we did not see under the special verdict was a biased lenity. And what I mean by that is it was only extended to the defendant who was named Jake or Deshaun, so who people presumed to be white or Black Christian defendant. The Muslim defendant of color did not get this more lenient treatment under the general verdict. So basically, he fared the same under the general or the special verdict. So we have this sort of lenity and bias emerging as strange bedfellows under the general verdict. And then we have this kind of impartial severity as two sides of the same coin under the special verdict.
So now I think I'll ask the question that most social scientists hate from lawyers, which is any immediate policy takeaways or implications that you think you can draw from your article? And obviously, this is a preliminary look at this phenomenon, and I'm sure that you're going to want to do additional work on it. But any immediate thoughts on what this suggests about special verdicts?
Yes, definitely. I think that these studies are intended as a starting point. My hope is that there will be robust empirical inquiries that follow by myself and others into the effects of verdict format. And I detail in the paper future empirical directions that I think would be low hanging fruit and high priorities to pursue in this regard. But I think that what we already have on hand is enough to question this reflexive hostility that the legal system has towards special verdicts, because verdict format is not just as a simple lever that, okay, it leads favors one party or another. It's a much more complicated situation than that. And I think that there's different legal values that are implicated. There's a balancing of legal values implicated because we see that on the one hand, special verdicts constrain jury bias. They also, we didn't talk about this so much, but those grudging acquittals were stemming from misunderstandings of the law that both general and special verdict participants exhibited, but the special verdict format sort of locked in those jury misunderstandings and forced the grudging acquittals. On the other hand, the general verdict, the flexibility that it gave jurors to follow their intuitions, enabled not just more jury discretion, but with discretion comes discrimination. So it also enabled biases. And, the question is, are we willing to make that trade-off? Does the laissez-faire format serve the interests of justice, or is it perpetuating systematic discrimination? So my main policy argument stemming from these findings is that we need to really re-examine the default in favor of general verdicts and instead make more empirically informed choices about verdict format in criminal cases by thinking about what is the kind of criminal justice system we want. Do we want to prioritize unfettered jury discretion with all its promise and peril, or do we want to channel that discretion toward more consistent and equitable outcomes? And the particular special verdict format used in these experiments might not necessarily be ideal. We saw the ways in which they had their shortcomings, but there's also different variations of special verdicts that could be tested. There's hybrid special general verdict formats I talk about in my discussion. So there's just so many different avenues that should and can be explored. And that's my main takeaway is let's have these honest conversations and acknowledge how jurors actually function and how verdict format functions instead of relying on this assumption that I think these data really challenge and show to be flawed in many ways.
Well, Avni, thanks for joining me on the podcast to talk about this new study and special verdicts in criminal cases more generally. Great having you on the show.
Thank you so much. I really enjoyed it. Appreciate the time.
Avni's article is a much needed and rich exploration of criminal special verdicts. Some of the results arguably confirm what you might have initially expected. In run-of-the-mill criminal cases, you might expect that special verdicts would help defendants because they hold the prosecution more closely to their burden of proof, which results in more acquittals. In more emotional cases, or cases where the law might be at odds with moral intuitions, then the special verdict can be a double-edged sword. It can be beneficial or harmful to defendants, depending on the specific context. What is odd in this space, though, is the universality of the legal preference for general verdicts in criminal cases. As Avni discussed in the interview, some of this universality comes from United States v. Spock, which is a Vietnam-era draft evasion case from the 1960s. And Spock was decidedly not a run-of-the-mill case, which perhaps proves the old adage that hard cases make bad law. What is especially striking is that the rule against special verdicts applies even when the defendant requests the special verdict. If you think about it, the evidentiary system frequently offers criminal defendants special dispensations. The beyond a reasonable doubt standard and the presumption of innocence. The ability of defendants to put their character in issue under Federal Rule of Evidence 404A2. And the right to present a defense in Chambers v. Mississippi that we discussed with Dan Medwed earlier this season are all examples of these dispensations. So why don't defendants have the right to demand a special verdict? After all that the special verdict demands from a jury is an accounting of what the law already requires. So perhaps the actual outcome in Spock was correct. To preserve the possibility of jury nullification and to recognize the importance of the jury as providing the conscience of the community, the prosecution can't demand a special verdict. But surely, Spock should not extend to defendants. Defendants should be able to demand a special verdict if the defendant so chooses. Will we see more special verdicts in criminal cases? Well, that of course remains to be seen. But I think Avni's research is certainly both illuminating and a step in the right direction. Support for Excited Utterance is generously provided by Vanderbilt Law School's Branstetter Litigation and Dispute Resolution Program, as well as the Texas A&M University School of Law. The associate producer is Alex Nunn, and the production editor is Anirudh Morella. Additional production assistance is provided by Lizzie Herrera, and background music is provided by Kirsten Castle-Greer, Felix Wong, and Alex Crew. I'm your host, Ed Chang, and I hope you'll join us again next time when we take on another new work in the world of evidence and proof.